Next presenter is Kathryn Casey. Kathryn Casey is a certified elder law attorney at Dutton, Casey, and Mesoloras. Katie is certified as an elder law attorney by the National Elder Law Foundation. She has practiced exclusively in elder law since 2004, when she began representing clients in adult guardianship and elder abuse, neglect, and financial exploitation litigation. Since then, her practice has expanded to include probate and trust administration, estate planning, retirement benefits, special needs planning, long-term care planning, Medicaid applications, and nursing home issues. She devotes a substantial portion of her time to helping families plan for the care of a loved one with a chronic care need. Katie represents her clients with continuity of care that extends from the creation of a long-term care plan to the execution, implementation, and administration of that plan. Katie commutes 20 miles on her bike each day through sun, rain, sleet, and snow. That when not at work, she enjoys being outdoors, gardening, riding her bike, and spending time with her husband and 16 nieces and nephews. Juris Doctor from DePaul University College of Law, Masters of Arts in English Literature from DePaul University, and a Bachelor's of Arts in English Literature from Virginia Tech.
Thank you so much, Dylan, for that introduction. And I hope everyone can see my screen. I'm a little technologically challenged, so.
You're good, Kathryn. It looks great.
Marvelous. Okay, that's fantastic. So I am here today to talk to you about caring for a loved one. And before I go any further, I really want to thank Elderwerks and all of the sponsors for having me to this event, but also for participating in the assistance to all of my clients for the caregiving that they provide their loved ones. A point I'm going to make now, which I know I will run out of time by the end of this presentation, so I'm going to make it now, is that caregiving is an incredibly challenging endeavor. I'm going to be talking to you about the legal aspects of caregiving, but I don't want anyone to ever forget how hard it is to care for someone with needs and how important it is to gather a community of resources around you. I can express from my own experience assisting my clients with their legal needs, I could not assist them to the extent that they need to be assisted if I didn't have resources like Elderwerks and the people who they've gathered together to support seniors and people with disabilities. It's incredibly important for everyone to have a team and everyone to have access to certain team members in the process of caring for their loved ones. One person is the lawyer, but that's not really, in my opinion, the most important person. The lawyer's involvement is often quite short-term. The most important person, in my opinion, for my clients are care managers and care advocates who assist my clients in advocating for their health care, for their good care, for their good long-term care, for the duration of their lifetime. So we rely on Elderwerks routinely, and I really can't thank them enough for putting together a group of professionals who's in a position to support not just my clients, but people who are caring for their loved ones. So what I'm going to be discussing with you today are the things we need to think about when we're caring for someone with a care-related need, an aging issue, a disability, physical issue, a cognitive issue, visual issue. Anything that requires assistance with activities of daily living is going to require a caregiver to be prepared. And that caregiver needs to be prepared legally, in addition to being prepared in other aspects. Today, we're going to talk about legal preparation in terms of healthcare decision-making, financial decision-making, legal care planning. How do we care plan from a legal perspective to access the very best care? And how legally can we deal with the cost of long-term care? Every caregiver, and I'm gonna refer to the person we're caring for as the patient today. I like the word because first of all, it's gender neutral. Second of all, it reminds us how much patience we need when we're caring for someone. It might be our spouse. It might be an adult disabled child. It might be our parent, could be our sibling. It could be one of our in-laws. whoever it is, that patient has the right to make their own healthcare decisions until they're determined to be legally incapacitated. So every caregiver needs to be conscious of what mental status the patient has when they're caring for them. Legally, they're not allowed to make healthcare decisions for them unless they're not able to make them themselves. And every caregiver then needs to be very cognizant of what is going to happen when the patient loses the ability to make decisions. And the law has a whole lot to say about that. And they've created a hierarchy in the statutes dictating who is allowed to make decisions for someone who can't make them themselves. So hopefully if you're a caregiver, you have the top thing that you need to make healthcare decisions for the patient, and that is the power of attorney for healthcare. And if you don't have that, then hopefully you fall somewhere on the lineup under the Healthcare Surrogate Act. And if you don't, then there's always becoming a court-appointed guardian for the patient in order to get legal authority over their healthcare decision-making. A caregiver's got to make a lot of decisions under a power of attorney for healthcare. It essentially allows you as the caregiver to make decisions such as where's the patient going to live? Are they going to remain in their home? Are they going to live in your home? Are they going to move to independent living, assisted living, a nursing facility? What doctors do they see? What medications do they take? Who's allowed to visit them? Who's not allowed to visit them? These are all decisions that come under the power of attorney for healthcare. Hopefully one has been executed by the time the patient is no longer decisional, because it requires legal capacity to execute the document. You can't sign a power of attorney for healthcare if you no longer understand decision-making. The caregiver needs to be aware of what the power of attorney for healthcare says about when they're able to act. Some powers of attorney for healthcare are effective immediately. Others do not become effective until the patient is determined to be incapacitated by a physician. There may also be a termination date in the document as to when your ability to make decisions for your loved one ends. Does it end at death? Does it extend past death for 6 months in order to authorize autopsy or final arrangements? And the agent caregiver also really needs to be aware of the fact that legally powers of attorney for healthcare are revocable even when the patient doesn't have capacity. And this puts caregivers in one of the hardest binds that they experience in caregiving when they are trying to make a decision for their loved one, when their loved one is not agreeable to that decision. Their loved one is not agreeable to that decision. And even though they don't have capacity, if they become upset with the caregiver who's acting as agent, they can revoke that healthcare power of attorney. They're allowed to take it back. Many people ask, and I should stop now and remind everyone that they are welcome to interrupt me at any time with questions. The patient is allowed to revoke their power of attorney for healthcare at any time, regardless of their capacity. And the agent might ask, what does revocation mean? How does one revoke the power of attorney? And the revocation can occur simply by the patient stating, I don't want you acting for me anymore. I don't want you making decisions for me anymore. I don't want you. And if someone over the age of 18 memorializes that in writing, then it's a revocation. So the patient technically doesn't even need to be able to write or sign a statement stating that they're revoking it. Caregivers who are acting as agents under powers of attorney for healthcare also need to be very aware that they do not have a duty to act. Caregiver fatigue is a very serious issue. And every agent needs to be reminded that they're not obligated to act. Even if they've started acting already, they don't have to continue. There is no legal obligation to act under a healthcare power of attorney. It can frequently become too much for someone who's caring for one disabled family member and then suffers an illness themselves, or takes on another disabled family member, or experiences a a family member who's recently been diagnosed with a chronic illness and needs care and attention themselves. So agents under powers of attorney for healthcare are not obligated to act. If you're caregiving for someone as an agent, you're not obligated to act for them. If you start acting, you are required to act well, meaning you're required to act with a duty of care. You're required to do a good job. You're required to use substituted judgment in making decisions, but you're not required to continue acting if you can't. And if you can't continue acting or can't even start acting to begin with as a caregiver, then you are allowed to refuse to act under that power of attorney for healthcare, and you're allowed to decline to act. So it isn't necessarily a life appointment. Another big question my healthcare agents have is, are they entitled to be paid for their services? And this is a very, very difficult issue because the statute makes no provision for healthcare agents being paid, which is patently unfair. The statute does provide for payment for the services provided under a power of attorney for property, which we'll talk about in a minute. But often it's the case, if you're caring for a loved one, you might only be the healthcare agent. You're not also the power of attorney for property. Maybe your brother is. Even if you are both, if the healthcare agency doesn't state that you're entitled to compensation for your caregiving, and it usually doesn't, then are you allowed to take compensation? And essentially what the law says is that caregivers who are providing care as a healthcare agent are entitled to receive compensation if there's a caregiver agreement in place. So someone who's acting as agent as power of attorney for healthcare might be providing care in ways they don't realize. They might have hired in-home help. They might also be providing some hours of help themselves. They might actually be doing nothing more than supervising caregivers and making healthcare decisions and coordinating care and advocating for care, and all of which are really important things. Frankly, they're sort of like running a small business. If you've ever managed someone's care for a considerable amount of time, it really does feel like a very, very full-time job, maybe two. Caregiver contracts allow caregivers and healthcare agents to be paid for their services as the agent and as the caregiver. It's essentially an employment contract where the person who's receiving the caregiving, the patient, is paying, maybe through the power of attorney for property, maybe not, for the services of caregiving. And it's a very fair and equitable way of making sure that the person who's really doing the lion's share of the work in terms of caregiving and care advocacy is receiving compensation for their services. What if there is no healthcare agency? What if no one signed a healthcare document? What if by the time we started taking care of the patient, they didn't have the ability to make decisions anymore, and so they couldn't sign a healthcare power of attorney? What happens then is we have the Healthcare Surrogate Act, which we rely upon. And the Healthcare Surrogate Act allows people to make decisions for someone who isn't able to make them themselves. They're able to make routine decisions, and they're able to refuse or discontinue life support. Here's the hierarchy though, and it might not be ideal in your family situation. So if you're a caregiver, you need to be on this list, and you need to be near the top of it relative to everyone else who's available. Otherwise, you don't have authority to make the decision. So the very top is the guardian. If you're not at the top of the list after that, spouse, adult child, parent, adult brother, sister, grandchild, close friend, if you're not up there, if you're not the highest person on the list, you might need to pursue guardianship in order to become the primary person who's able to make decisions. So my clients who are in a caregiving role are also, in addition to physically caring for the patient, or at least coordinating the care and advocating for the care, they are almost always also in charge of managing the finances. And that is a truly overwhelming and sometimes very intimidating job. And it generally is the case that we're handling finances for another person through a power of attorney for property, We really want to have a power of attorney for property in place if we're caring for someone. And we want it executed in advance because, again, it requires legal capacity to execute. And so if it hasn't been done in advance, we're going to need to go get guardianship. The power of attorney for property allows us to take over financials, all of the financials, all of the financial decision-making, the bill payment, entering into contracts, dictating investments, transferring money between accounts, all of the things that are critical when you're trying to care for someone. People with care require care, which is not inexpensive. And it does require some relatively sophisticated financial management to take over someone's financial life. It's hard enough to manage your own financial life, frankly, without having to take on someone else's financial life and make sure that the financials are being managed in a way that's going to support the caregiving needs during the patient's lifetime. If you're acting under a power of attorney for property, you might need help. And that help might include some legal advice to advise you of what you need to do as power of attorney for property. Are you even allowed to act under it? Again, with powers of attorney for property, like the powers of attorney for healthcare, some of them are effective immediately. Others are not effective until a physician determines that the patient's incapacitated. So you might need legal assistance in getting the documentation in place to make sure that the patient is actually determined incapacitated so that you can actually use the power of attorney at the bank and start taking over the financial decision-making. You might also need help in the sense that you need to delegate some duties. Power of attorney for property doesn't mean you are literally supposed to do everything yourself. It does not mean that you are the realtor in addition to the lawyer, in addition to the CPA, in addition to the financial advisor. You don't even necessarily have to be a bookkeeper. These are all people to whom you can delegate duties. So again, you can recruit a group of professionals to assist you and alleviate that burden of acting as power of attorney for property and managing all of the financials. Unlike the healthcare power of attorney, almost every power of attorney for property does include an entitlement to reasonable compensation. And I have to say, I think I advise every single client I meet who's acting as agent under power of attorney for property to, if not take fees for their time, to at least keep track of their time in the event they want to charge fees in the future. I think when people start acting as power of attorney for property, they're not quite aware of what they're getting into and just how challenging it is to manage someone's financials. It really is incredibly challenging, and it becomes more challenging over time. So if we start keeping time records from the beginning, then by the time we realize that this is significantly taking over a large portion of our lives, and it is valuable work to society to be taking care of a patient, that it is worthy of reasonable compensation. And I strongly encourage almost every client.
Hey, Kathryn, someone has a question.
Great.
They asked approximately how much does it cost to hire a lawyer to work out POAs, etc.?
That's a really good question, and it's different in every case. So what you'll want to do when you're hiring an attorney is first determine whether or not there's a long-term care need or a potential long-term care need. I strongly encourage clients who have a potential long-term care need to get their estate planning done through an elder law attorney rather than a traditional estate planning attorney, so that that attorney can also address long-term care issues. Every attorney is going to charge a different price depending on certain things, such as how many documents do you really need? Do you only need powers of attorney? And if so, how much wealth do you have? And then they'll set a fee relative to that. Do you need something else in addition to the powers of attorney, which would benefit you but increase the cost, obviously? So I can't give you a firm number on what it would cost, but I can commiserate with you in that it is challenging to find a good attorney, and it's challenging to figure out what a fair price is. And I encourage you to call and ask and talk to people. A lot of my clients, I'm not the first person they've talked to. They've often talked to several people. Unfortunately, that's sometimes necessary before you find the right person. So the power of attorney, if you're an agent, and this is why I tell my clients to start keeping time records from the beginning, there's a statutory requirement that if you're acting as agent, you're supposed to keep immaculate records. You're supposed to keep an accounting of literally everything you do. That's really hard for people. Most people can barely balance their checkbook, let alone keep an immaculate accounting of how they're managing money. It's really important to keep records because at any time under the statute, someone with an interest in the patient can come to you and say, I'd like to see that accounting. I'm advocating for the interests of the patient. And the statute is very protective of patients as a protection against exploitation, financial exploitation and abuse. And it burdens the agent with having to provide an accounting when requested. That duty to account is a duty which is imposed on agents in regards to adult protective services agencies, the ombudsman, public guardians, or courts. Another very important issue that agents under power of attorney need to be aware of is the gifting issue. And that is that powers of attorney are not allowed to benefit from acting as agent beyond being paid reasonable compensation for their efforts. They're not allowed to simply take, $10,000 here, $20,000 there. They're not allowed to use the patient's money for things that don't benefit the patient. So if you're acting as an agent for a parent, you're not allowed to use the parent's money to pay for your child's college education, even if your parent is telling you, I agree to you doing that. The law says if you're acting as agent, you are not allowed to use the money for anyone other than the patient. And not everyone's aware of that. And they often get in very big trouble when they do use the money for other people. It can cause lawsuits. It can cause reports to adult protective services agencies and financial exploitation investigations. It can also cause major problems with Medicaid if the funds run out and the patient requires long-term care. When you're caring for a patient, you might be really tempted to add your name to their accounts as a joint tenant. People who are planning for the future often think, gosh, I'm too busy to go get powers of attorney, or I don't want to pay for it. I'm just going to put my loved ones on my bank accounts as a joint tenant. And it's easy. It's fast, it's effective in a lot of ways because it avoids probate at death. If you put someone on as a joint account holder on your bank account, they're allowed to just take that money when you pass away, no need to go to court. It's effective for estate administration because if someone is on as a joint tenant, they're allowed to write checks, they're allowed to make withdrawals, they're allowed to use debit cards freely without even using the power of attorney. I have to tell you, I have had the worst experiences with joint tenancy. Every joint tenancy situation I've seen has gone very badly. And the problem with joint tenancy is that when you add someone else's name to your bank account, or when you add your name to theirs, then you're subjecting that account to the creditors of both people. So to give you an example, if a parent is tempted to add an adult child as a joint tenant for purposes of estate management, and they add that adult child not knowing that that adult child has a lawsuit judgment against them, or maybe a child support order that was never fulfilled. Well, by virtue of adding that adult child on the bank account, that adult child's creditors can seize the account. And they can do it even though the money in that account wasn't earned by that adult child. So you think you're just adding the adult child for purposes of convenience, but what ends up happening is you're actually saying to the adult child and saying to society, this account is now your money. It is now your money. It's considered what the law calls an inter vivos gift. You have just gifted your money to that person, and all of their creditors can come and seize that account. I've seen this happen too many times. Another problem with adding a joint tenant to account is that that joint tenant has the right legally to get up in the middle of the night, go to the bank, take out all the money, and flee the country. So you might think you're adding someone who is responsible and who is not going to do that. But if they do that, if they go to the bank, they take all the money and they leave the jurisdiction, there is nothing anyone can do to get the money back. Frankly, even if they don't leave the jurisdiction, you can't get the money back because as a joint tenant, under the law, they are legally allowed to take all of your money. That's what making someone a joint tenant means. Another issue I've had with joint tenancy, which no one thinks about, but I think about every day, is that parents often think, well, I'm likely to go first, right? I'm going to need a nursing home first. I'm going to pass away first. So they'll add their younger adult child to the bank account for purposes of convenience. And what happens? That adult child ends up having a stroke. And it's that adult child who ends up needing care and nursing home assistance. And in having added that child as a joint tenant, all of that money in the bank is now considered by Medicaid to be available for that adult child's care. And it is very, very hard to get that money back or protect it once that's happened. Medicaid is going to say 100% of the money in that joint account belongs to the person who's going on Medicaid, even if that person never contributed a dime. Very, very bad consequence. So I don't recommend joint tenancy. I recommend a trust instead. A trust is so much more protective of people from financial exploitation, from abuse of their money. It protects in all kinds of ways. For example, it allows you to manage your money. It allows you to choose who else is going to manage your money while you're alive, but incapacitated. It also allows you to achieve probate avoidance. So just like adding the joint tenant on the account, the trust bypasses probate, and those accounts go automatically to your beneficiaries. It provides tax planning. It provides disability planning. It provides so much more legal protection than joint tenancy accounts do. And they're not hard to set up. They're really not that hard or that expensive to set up relative to the value that you get out of them in the long run. An important thing to know, though, when we're dealing with trust is that it is not worth it to go to a lawyer and to get a trust document and to sign off on it and then to stick it in a safe deposit box and never think about it again. That doesn't help you. The trust has to be funded. So if you're caring for someone who has a trust, you really need to make sure that that trust is funded. It's one of the things that's at the top of the list in terms of financial management that you need to worry about. When you're looking through all the financials, figuring out, is the trust funded? Where are the assets? How do we get them into the trust so they can be easily managed and avoid probate? Other things that the trustee needs to worry about when you're caring for the patient and acting as trustee is, what are your duties? What are you supposed to do as trustee? One of the hardest things to do as trustee, frankly, is to figure out when the trust applies to assets and when the power of attorney for property applies to assets. And that's something you should really obtain legal advice about, to figure out the difference. Then you need to consider that as trustee, you've got to prudently administer the trust and invest the assets, and you've got to be 100% loyal to the trust beneficiary. Now, if you're caring for someone and you're acting as trustee of their trust, successor trustee probably because they can't act anymore, you can only use the money for the patient. You're not allowed to use it for yourself. And you're accountable to that patient, but in addition to that, and this is the hard part about being a trustee, you're also accountable to the beneficiaries who will come after the patient has passed away. So let's say you're acting for your spouse and you're acting as trustee and caring for them. You're probably the primary beneficiary of your spouse's trust. So you're really only accountable to yourself in a lot of respects. Makes it a lot easier. But what if you're caring for a parent or a sibling, and when your parent or sibling passes away, the assets then go on down to their children, your siblings, your nieces and nephews, other family members? Well, this can put you in a really bad spot because now you are accountable to family members who might want to see your accounting and legally are entitled to see your accounting of how you manage the trust assets. Very much like being a power of attorney, really it's the same duty of accounting and accountability. So people who are caring for patients are also often very concerned with asset protection. And that's when they come to me and they ask me, what is an irrevocable trust? You know, how is an irrevocable trust different from a regular trust? And if you're caring for someone, you might want to establish an irrevocable trust, which protects money from the cost of long-term care. And what you need to be aware of when dealing with irrevocable trusts or talking to people about irrevocable trusts, particularly lawyers, if you're interested in them and shopping around, is that irrevocable trusts are, like they're called, irrevocable, meaning you can never take them back, they can never be changed. So if you're caring for a spouse and they want to set up a irrevocable trust, or you're caring for a parent and it's a good idea to set up an irrevocable trust, you got to keep in mind that it's sort of a one-shot deal. When an irrevocable trust is established, you have one chance to get it established correctly and to get all the terms correct. Because if they're not, we cannot undo them. So you have to be really, really careful when shopping around for irrevocable trusts. And no one who is in a caregiving role who is interested in irrevocable trust should establish them without consulting with someone who is extremely knowledgeable about the consequences of irrevocable trusts, particularly on long-term care and Medicaid planning. So they need to understand what impact that's going to have on Medicaid, so you know what you're getting into before you get into it.
Hey, Kathryn, there's another question. If you as attorney create a trust for a person, do you help them fund the trust?
That's a really great question. So yes and no. Let me tell you how I can help my clients fund their trusts. What I can do is I can transfer their real estate into their trust through what's called a deed and trust. So real estate in Illinois has to go through probate at death unless it's in an irrevocable trust or unless there's a transfer on death instrument recorded on it. So deeding the property into a trust avoids probate, and it is the job of the lawyer to get that property into trust. It is not the job of the client. The client would not be able to execute and prepare and execute and record a deed on their own. In addition to preparing, executing, and recording the deed for the client, I also provide them with what's called funding instructions. Funding instructions is essentially a memorandum explaining how you get your assets into the trust and which assets go into the trust and which assets do not. Some assets should not go into the trust. For example, IRAs are not going into your trust. Your car, it's not going into your trust. But things like your savings account, your brokerage account, your checking account, they're all going into your trust. And the memorandum essentially says, take the binder, the estate plan binder, the binder with all of your estate plan documents in it, the trust primarily, but the powers of attorney too. Take the whole estate plan binder to the bank or email or fax the documents to the bank and ask them to retitle the accounts into the trust. So what does that mean? That means, let's say you have a checking account called the Katie Casey checking account. The checking account name on it says just Katie Casey. If I call the bank and say, please put that into my trust, the bank will retitle that same bank account. Instead of it being Katie Casey, it will be called Katie Casey, trustee of the Katie Casey Trust. Nothing will change. Everything will stay the same. It's still your money. You are in control of it. It's just a matter of whether it says you individually or you as trustee. Now, I can't actually go to the bank or call the bank and do that for my client. So I provide them with the funding instructions and then follow up with them to make sure that they have followed up with their bankers and financial institutions to get that done. It really is important to get it done because without that, there's no value. My favorite trust when we're caring for someone with a chronic care need is what's called the special needs trust. So a special needs trust is very special indeed. The special needs trust is essentially a trust which allows us to keep our money but continue to qualify or become eligible to qualify for SSI or Medicaid. Special needs trusts are really, really important in a couple key situations. One situation is where we're married or we're in a partnership where we care very much about someone else and we want to leave them an inheritance. We want to leave them our estate. If we leave them our estate and they are a disabled person, meaning they require caregiving, they need assistance with activities of daily living, we leave them an inheritance, then they're able to manage that money on their own, which they might not be equipped to do. And all of that money will be countable to pay for their care costs, and Medicaid will not pay for any of their care costs. If we leave an inheritance to our patient or loved one through a special needs trust, we could potentially leave them a very large sum of money. And under the Social Security Act, under the OBRA amendment to the Social Security Act, Medicaid is not allowed to count the money in the special needs trust. So for special needs planning, for Medicaid purposes, individuals are not allowed to own more than $2,000 and qualify for Medicaid. All assets need to be spent down to $2,000 before qualifying. It's not good to have $2,000 when you are a disabled person or when you require caregiving. If you can only have $2,000, but you could also have $50,000 from an inheritance, which is in a special needs trust managed by a responsible party, you're still able to receive Medicaid, and your special needs trust is going to last a whole lot longer because Medicaid is paying for the care costs, but the special needs trust is paying for things like transportation, therapy that's not covered by Medicare or Medicaid, a companion to come spend time with the patient while they're in care. The special needs trust option is extremely popular amongst my clients who are married or in partnerships. And they are worried because they're the primary caregiver. So these are clients who are caregiving for a spouse. They're very concerned about the fact that if they pass away first, that then their disabled spouse will have management of all the money and all of those assets will easily be wiped out by the cost of long-term care. And it gives them a great deal of peace of mind to leave that inheritance to their spouse through a special needs trust. The same situation applies when we have a disabled adult child. And when we're concerned we're going to pass away first, who is going to care for that child and who is going to manage money for that child? And we don't want that child to be relegated to only having $2,000. We want to make sure they have access to public benefits and still have funds set aside to supplement their needs. And a special needs trust in that manner is extremely comforting to a parent of an adult disabled child to make sure that child's needs are going to be met and they're still going to continue to receive Medicaid. So special needs trust can be created by the caregiver, and in order to leave an inheritance to the patient in a way that doesn't interfere with Medicaid or public benefits planning. Special needs trust can also be established with the patient's own money. So if the patient themselves has more than $2,000 in assets and it's at risk of being totally exhausted on the cost of long-term care, the patient themselves, through their power of attorney, can establish a special needs trust and put that money into the special needs trust and protect it. And really the beautiful thing about the special needs trust, and the reason I love it so much, is because it allows the patient to receive Medicaid funding to pay for their care while keeping resources that support their additional needs. We don't want to be down to $2,000 if we're living in a facility. Medicaid is not going to pay for really important things that we need as a person who requires care. It's not going to pay for clothing or personal supplies or transportation. It often doesn't pay for basic dental needs. Things like that can be paid for through the special needs trust. What I love about it more than anything is the special needs trust can be used to pay for companion services and care advocacy. So imagine you're a primary caregiver. You probably already are a primary caregiver if you're attending this session. You're caring for someone and you're worried what will happen to their care plan if you can't care for them anymore. It's what I worry about. It's what keeps me up at night when I consider my clients. Everything about the care plan for this patient is dependent on our caregiver. I'm always gravely concerned about the health of my caregiver, the amount of respite my caregiver is getting, how long my caregiver is going to be able to keep providing the care. Because if the caregiver can't keep doing it or the caregiver passes away first, that patient still requires care. They still need a care plan. And if they've lost their primary caregiver, but they have a special needs trust, then the first thing I want to use that special needs trust for is essentially to pay to hire a companion and a care manager to replace my primary caregiver. It is well documented that people who are living in facilities have better outcomes when they have companions, when they have care managers. In any kind of long-term care setting, the outcomes are better. And the use of the special needs trust money for that purpose is really invaluable to make sure that that patient's care plan continues on long past the loss of their primary caregiver.
Hey, Katie, we're going to start Q&A in about 4 minutes, and there's a question that we just got posted. Can you later change your mind if you created a special needs trust?
Well, you can change your mind about a special needs trust if you're creating one for someone else. So if you're creating a will or trust and in it you're saying, I'm leaving an inheritance to this person through a special needs trust, you can change that at any time before you pass away. But if you're establishing it while you're alive, or you're establishing it with the patient's money, it too is an irrevocable trust. So remember the irrevocable trust rules. The special needs trust is basically an irrevocable trust. Once you've established it and funded it, it is a permanent thing. So it's again, like any irrevocable trust, it's a very, very serious decision that needs to be entered into with a great deal of advice from an attorney who's experienced doing special needs trust to make sure it's the right thing to do. So care costs are what's keeping my caregivers up at night. Caregiver costs, all care costs are really the most anxiety-driven part of caregiving for a lot of people. And the reason is that activities of daily living, driving, meal preparation, bathing, toileting, dressing, all of these things, they are not paid for by ordinary health insurance. They're not paid for by Medicare. They are not paid for by anything other than long-term care insurance, which very few people have. So there's a real misconception about ordinary health insurance and Medicare. And we think Medicare, and Medicare is, by the way, I love Medicare. I think Medicare is the greatest healthcare program we've ever had. It does so much for my clients. I want them to keep Medicare in place forever. Even if they go on Medicaid eventually, they always keep their Medicare in place because Medicare does pay for so much great stuff. It pays for the doctors, it pays for the hospitalizations, it pays for up to 100 days in skilled nursing for rehab. It covers so much of what we need, but it doesn't cover the things on this list. It does not cover helping someone with a disability or a chronic care need get through their day. It does not provide custodial care. It does not provide for just basic assistance in activities of daily living. Only long-term care insurance does. That's it. Very few of my clients have long-term care insurance. Very few caregivers I know who are caring for patients have long-term care insurance helping them. And even when the patient does have long-term care insurance, it is very frequently totally inadequate, meaning it pays some amount. It'll pay maybe $50 a day, maybe $200 a day, but it's not covering enough to pay for what I call custodial care, which is really 24/7 supervision and assistance with caregiving. And this is why so many caregivers come to me to talk to me about Medicaid, because we are worried about running out of money in the face of long-term care and caregiving needs. We're worried about what will happen when those funds run out. We're also very interested in figuring out whether we can keep any of that money for someone else in the family. For example, and you've probably heard about this, there are protections in Medicaid planning for spouses, people who are married. There are also certain protections for adult disabled children. And there are also protections for caregivers. If you're a caregiver child, there are certain protections for you under Medicaid law, which you really need to explore if you're caring for someone, and you need to consider them in advance because they often need to be taken care of or addressed in advance. Medicaid is a program which pays for assistance with activities of daily living. Medicaid is essentially our country's long-term care insurance policy. Medicaid is a federal program. It is administered by the states, and it applies to long-term care in skilled nursing facilities, nursing homes. It applies to supportive living facilities, and it applies to in-home services for people both over and under 60. And it essentially provides custodial care, care for someone who needs assistance with activities of daily living on an ongoing basis. I'm not going to get too far into the Medicaid eligibility rules today because they are so different for different situations. So I encourage people, you might think you do not qualify for Medicaid and you never will qualify for Medicaid. You might think the person you're caring for is never going to qualify for Medicaid and everything is absolutely lost. Don't assume that you won't qualify, and don't assume that there aren't ways to make sure that the funds used for caring for someone can't be used for the people actually caring for that person. I don't want my client caregivers to be providing care without some kind of compensation, without some kind of reimbursement for their expenses and their time. There are many ways under the law in which a caregiver can protect themselves financially in caring for their loved one. And it really is worth exploring in advance to make sure that the caregiver does not end up in a financial situation that is as bad or even worse than the person for whom they're caring. So with that, I will turn it over to Dylan to take any questions that might be waiting for me.
So you have one question. If I own a house with a partner, joint tenancy with right of survivorship, and partner number one needs Medicaid nursing care, can partner number two lose the house? Is the house counted as an asset for Medicaid?
That's a great question. And by partner, I'm going to assume you mean not legally married or in a domestic part, in a legal civil union. So under the law for Medicaid, only spouses who are married to each other are allowed to protect homes from being counted for Medicaid eligibility. So if you're a partner and your partner requires Medicaid and you own a property jointly, then Medicaid is going to count the house as an asset. However, there is a very little known exception which you as the partner can claim, and it's called a fractional interest exception. And essentially what it means is that if you own the property jointly with your partner and you sign a statement stating you're refusing to sell it, Medicaid has to approve your partner for Medicaid benefits because you're a fractional owner and you're refusing to sell that property. Medicaid, however, even though they're approving your partner for Medicaid, is allowed to file a lien on the 50% portion that your partner owns. And that lien will be equal to the value of the Medicaid benefits paid on behalf of your partner. Might be, $10,000, might be $200,000, depending on how many Medicaid benefits are paid out and for how long. That lien will just sit there on the property until you sell it. So Medicaid isn't going to take the house away. They're not going to evict you. They're not going to foreclose. but the lien is going to sit there and it could potentially encumber 50% of the value of the home, such that when you go to sell it, it is no longer valuable. Half of it's gone, and you're only going to receive 50% of the equity for that property. So that's a very serious issue when we're owning property jointly, and that's an issue that hopefully can be addressed well in advance in an effort to try to protect ownership of the home. What we can't do for Medicaid purposes is you can't have your partner just deed you the property, because that would be considered a gift, and there would be a 5-year look back period imposed on that gift and a penalty if your partner needed Medicaid. So there are other strategies for protecting homes that are owned jointly with partners. And because it's complicated, I think, as I've demonstrated, it's a really good reason to talk to an elder law attorney who practices in Medicaid applications.
Well, I just want to say thank you, Katie Casey, for presenting today, and thank you to Dutton, Casey, and Mesoloras attorneys at law.